If you have a legal question and you've been waiting to ask John Fuller that question, this is the time. Today is Wednesday, January 21st. 2015. If that's the date on your calendar, then you're listening to a live show and your calls are welcome and invited. The phone number is 622-9622. John Fuller is here hosting this program called Legally Yours. John is an attorney here in Ocala at the law firm of Fuller and Fuller. The other Fuller is his beautiful wife, Janet, and we haven't seen her in a couple of years, but she's still in the practice. And John, you got a phone call right off the back, so good morning.
That's great. Good morning, Larry, and thanks for our very prompt caller.
Yes, and I like early callers because that means you can have a little bit of a lengthier answer if you need to have one. Good morning. You're on the air with John Fuller.
Good morning. This is Kathy.
Good morning.
John.
How are you?
Good morning, Larry.
Hey.
I hope I can explain what I'm thinking about here. If somebody is negotiating with a company, let's say a TV company, cable company, and they have a phone conversation, they agree upon one amount, and then the bill comes in for a different amount, if the company accepts the bill for the discussed amount, can they hold the person responsible for the larger amount?
Well, like so many things in the law, the answer to that is they possibly can, and let me explain. Verbal discussion is not the best way to document a separate agreement. If they claim a certain amount of money due and they have sent you a bill for that amount, and that amount is more than you think you owe, you can reach a separate agreement on a lesser amount, and that is called an accord and satisfaction. That means you have reached an accord on a new agreement, and upon payment of that new amount, that satisfies the debt. Now, in order to document that, it is a very good idea that you should have written the company, referred to the conversation, the date of the conversation, the individual you were talking with, and that you disputed the bill, and they agreed to accept a lesser sum in the amount of blank, and you are tendering your check in the agreed amount of the new, of the revised payment in full satisfaction of bill number so-and-so or account number so-and-so. Now, if you just agreed on an amount and verbally you didn't do anything else, and they sent you another bill, that is called an account stated. And if someone sends to a customer or a client or someone they have a relationship, business relationship with, a bill for services rendered, that is called an account stated. The amount on that bill is presumptively valid and needs to be paid unless you protect yourself by writing them a letter and saying, I dispute your bill number so-and-so based upon the fact that your representative on such and such a day, agreed with me that the bill was in error and it would be adjusted and I owed you blank and I'm enclosing my amount. Now, if they don't accept your check and say, well, whomever you were talking with didn't have the authority to do that, then you have at least not let them get a legal presumption of a correct bill. You've disputed it. You can then go to court, and the judge can then decide whether or not you had a valid accord and satisfaction, whether or not the bill is valid, whether your interpretation of what you should owe them is valid, but you won't be stuck with having acquiesced in that new bill. So that's what you need to do.
Wow.
Okay.
That was a great answer.
What my person is lacking is the written document.
Oh yeah, you need to have anything
okay.
that you do.
Right.
You need to have a paper trail.
Right. Thank you so much.
Yes, ma'am. Thanks for calling.
That was great.
Bye-bye.
Wow. That was great. You have another phone call, too. By the way, I appreciate the early calls because, as you could hear, for John to really show you his skills, he needs a little time. This is what he does for a living. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller. It's always good to hear from you.
And likewise, it's good to hear from you. How are you?
Oh, pretty good. That last call was very interesting because usually that's exactly what a lot of automobile dealers do. You will go in and you will say, look, I do not want to have a payment more than, say, $400. It comes back $475 or whatever after everything, and it's usually like a month or so after. And I was wondering, and I doubt it, but I was wondering if that kind of applies to them after you've done all the paperwork and you've gone through everything. But I noticed that's almost a standard practice with a lot of automobile dealers. They do that basically exact same thing that the last caller was talking about. I'll hang up, and it's always good listening to you, and I'll listen to your comments on air.
Thank you, sir. Well, you make a good point. Some of that may be caused by just simple confusion. A good way to do it, and I've noticed with some of the dealerships that I have taken my truck or a vehicle in to be serviced, they will have on the service write-up sheet a blank for an estimate of what the expected costs are going to be. What I have done and what I recommend that people do is to have the service writer, when the vehicle is taken in, to write on there, if repairs and service will exceed the estimate of X amount of dollars, do not perform without calling Mr. John Doe at such and such a phone number to receive additional authorization to exceed the estimated amount of $200 or whatever is put in. Then you have them in a contractual binding that if they exceed that amount, I think you have a good argument that they did so at their peril. And that's a good way to avoid any misunderstanding, because if you just let them put down an estimate, which they normally do, and I think Florida law may even require that, I'm not sure about that, but if they put down estimate $575 and then they bill you $540, that's a relative de minimis amount in relationship to the amount of the estimate. It's less than 10%. And one would expect they might have a good argument that this was an estimate. There was no requirement that it was a maximum authority for the repair.
Right.
And so that's at least a practical tip.
Well, what's interesting about both calls is that it sounds like in order to prepare yourself, I mean, we always enter every relationship in a trusting way.
Yes.
But if you don't, if you instead say, what if this guy isn't trustworthy? Then you do those things to be prepared for that paperwork.
Well, and that's the system, in an ideal world, you wouldn't need a lot of the things we talk about, okay? And in a kinder, gentler word, I remember my father did 90+% of all of his business on a handshake because he had a wonderful relationship with his customers and the people that he worked with, and he was in business. In fact, the business is still operating under his name, Fuller Amusement. It was started in 1929.
That's your dad?
That was started in 1929 by my father, and Kurt Folsom now owns it and operates it and does a fine job. He and his wife are great folks. I think the world of them, and they continue to use and respect my father's name, which I am grateful for. I think it's a respectful thing to do for my dad because it's been continuously operated as an amusement machine, jukebox business, pinball machine, arcade equipment ever since international. Ever since 1929. No, it's local, but it covers all of Central Florida. Yeah.
Is that right?
But in any event, but in those days, my dad and the people that he did business with 20, 30 years with the same family.
Wow.
And that was kind of the norm.
Do you have a pinball machine in your home?
The bottom machine. I had, and I gave it, I had, this is an interesting thing, it has nothing to do with the law, but when I was 7 years old, my father gave me a 1948 Wurlitzer, and it was very unique. It was one of the first models made after World War II. It had a polarized rotating glass in with a white light in it to break it up into colors instead of just colored plexiglass. It's one of the most desirable collectibles, and I gave it to my good friend and colleague, Bill DeCarlos. He and I have tried 35 felony cases in federal and state court to a verdict, and I think we won all of them, or at least substantially all of them. And Bill is a very dear friend and a 41-year colleague of mine, and he collects those things.
Wow.
He had it completely refurbished in Chicago, and it is now valued at a tremendous amount of money and is considered the number 1 or 2 collectible jukeboxes in the country. And that was my 7th year birthday gift from my father.
Wow.
And it still has all the top records from the Billboard 100 chart on it.
Oh, really?
From 1955 or 6. Elvis and
Wow.
Jerry Lee Lewis and Johnny Cash and all those guys were on a label called Sun Records,
Sun
which you may
Records.
not remember from
I do.
Memphis, but it was loaded with that.
And you have a phone call, John. Good morning. You're on the air with John Fuller.
Good morning. I heard about a very strange case. It's not from Florida, but I was wondering if Mr. Fuller could kind of put on his judge's robe and see what he would think. It was a 5-year-old boy who had been invited to go to a very expensive birthday party for one of his friends. I think it involved skiing. And he committed to go to the party, and then at the last minute he couldn't make it. And the parents of the child who was having the party, who had, booked the ski trip, are now saying that they want this 5-year-old's parents to compensate them for the financial loss they took because he didn't attend the party. So we have a 5-year-old basically being taken to small claims court for not going to a birthday party. And Mr. Fuller, I just put on your judge's robe and tell me what you think about that case, and I'll hang up. Thank you.
Well, let me make it clear. I've never been a judge. I have no desire to want to be a judge, and I don't have a judge's robe. I think, and I don't know anything about what state it is or the laws of those states, but it sounds like whoever is filing that case is going to have a very uphill battle to get any legal remedy through the legal system, even in summary claims court. And that's a shame when the system perhaps gets taken advantage of by people who have more time than they know what to do with, and too little common sense.
Using the system to
But in any
make a
event,
point or whatever.
at least it's summary claims, and it should be summarily resolved without a lot of time and effort. But no, I think the gentleman, by just the way he phrased his question, was opining on the apparent absurdity of that situation.
I think so, too. We need to take a little break, and we'll be right back.
The weather is brought to you by myfwc.com. Safe boating is no accident. It'll be partly sunny today with a nice afternoon, the high 72 to 76. For tonight, partly cloudy skies, lows ranging from 50 at a few inland spots to 58 along the coast. Another nice day tomorrow with clouds and sun and a high of 73 to 77. And for Friday, mostly cloudy and breezy and warm with a couple of showers, perhaps an afternoon thunderstorm, the high 74 to 78. From the Florida Weather Center, I'm meteorologist Joe Lundberg.
Whether you're building it up or knocking it down, get it done, rent it now. Sunbelt Rentals is here to make your job a little easier. Our knowledgeable staff will help you find the right equipment for any job, big or small. Did you know that Sunbelt Rentals carries heaters, air conditioners, generators, lighting, traffic control, and so much more? So whether you're building it up or knocking it down, we've got the equipment you need. Get it done, rent it now. And right now, for a limited time, you can have it for less. Just by mentioning this ad, if you rent it Friday afternoon, you can keep it the whole weekend and only pay for one day. But this is a limited time offer, so stop into Sunbelt Rentals today, Northwest 27th, just a quarter mile east of I-75. For more information, just give us a call, 352-369-9101. 352-369-9101. Sunbelt Rentals. Get it done, rent it now. 352-369-9101.
Let's face it, nowadays it can be hard to find American-made products, and that's something that Cabinet Sales of North Florida is well aware of. That's why they're an authorized dealer of Wellborn Cabinetry, family-owned and American-made since 1961. Cabinet Sales of North Florida is your answer for complete turnkey kitchen remodels and whole house cabinetry. Their cabinets are finished with solvent-based enamels for a long-lasting finish that's second to none. Available in an incredible selection of door styles and colors to choose from to turn your dream kitchen into a reality. In-house design and drawing services are available. Come by and see our displays for yourself at the Floors of the Villages, 3935 County Road 216 in Oxford, or Exquisite Design Kitchen and Bath in Bellevue, right across the street from the Bellevue Library. So whether you're looking for bookcases, kitchen, bath, or outdoor kitchen, Cabinet Sales of North Florida is your one-stop source of quality cabinets. For a free estimate, call 352-427-2647. That's 352-427-2647. Cabinet Sales of North Florida.
The LPGA Tour will kick off the 2015 season right here in Central Florida at the inaugural Coates Golf Championship presented by R&L Carriers, January 26th to the 31st at Golden Ocala Golf and Equestrian Club. Kids 12 and under get in free with a ticketed adult, so bring the entire family to see 120 of the world's best female golfers compete on a nationally televised stage. For information and tickets, visit CoatesGolfChampionship.com.
All right, 10 minutes before 11 o'clock, 10 minutes left in the show, and this is a great opportunity for you to call in 622-9622. John Fuller is here to answer your legal questions, and you have another phone call coming in. Good morning. You're on the air with John.
Hi, how are you? Larry.
Good morning.
Mr. Fuller, Tom.
How are you?
Wonderful. The gentleman that had called earlier, the backstory on that little 5-year-old being his parents being sued. It's actually a UK case. It's in England, and there was a written RSVP where you had to return a written RSVP, and it said on the RSVP that after you RSVP, if you no-show, there will be a minimal charge recouped by the family that it was throwing the party. So does that make it any different now?
It could. I mean, that's I have said on this show many, many, many times, and I appreciate you calling with that additional factual background, because I'd never heard of that situation. Obviously, being in the United Kingdom, I don't know anything about what their law is, but you can have implied contracts where if you receive an invitation and you RSVP, you accept the condition that is stated on it, and then if you breach the condition, it may be an action that would lie in contract. But that's a whole lot different than the facts that the first caller presented, that a 5-year-old got invited to a birthday party and he didn't go, so now they want him to pay a pro rata cost for the cost of the birthday party. That's a whole different scenario, and it makes a wonderful point, and what the point I want to make is that the law pivots upon the factual details. You can ask me about the basic fundamental principles of contract law, and they're fairly straightforward, although it gets a little complex when you get in conditions and preconditions and offer and acceptance and consideration and contingencies and that sort of thing. But the principles are basically not rocket scientist stuff. The difficulty is in applying the legal principles to the unique factual scenario, and the devil's in the details. So that's an excellent example of why the law is very fluid. It's often impossible for a very meaningful projection of what the outcome will be, because a lot of times when you start a lawsuit, you've got to develop the facts as you go along. I mean, you talk to a person, they tell you what they know or what they believe, and they tell you that presumably honestly and in good faith, but you may then, once you get into the lawsuit based upon that, talk to 3 other people who have different points of view, different interpretations of the facts, and then you have a factual dispute. And that's what a judge or a jury has to resolve. But thank you for calling and making a very good point.
Thank you, Tom. We got another phone call. Good morning. You're on the air with John.
Good morning.
Good morning.
I have a question. I know somebody who's had like a DUI charge, and it's been going through the court, but it's almost going on 2 years now, and the public defender, who seems very good, keeps doing calendar calls and delaying it. And so I'm kind of curious why, they do that. I guess they keep calling witnesses and the witnesses don't show up. But is that a good thing when you get more time between something like that?
Well, I have no idea what the reason or the justification are for the continuances of the case. In order for them to be continued, there has to be an order by the judge based upon good cause, and I can't speculate on what would be the reason or justification for any continuance. I will tell you, now this is a cliche, has nothing to do with this case or any particular case, but a lot of criminal defense lawyers say that no individual who's charged with a crime ever got convicted and sentenced to jail until they went to trial. And the longer they don't go to trial, the longer there's a chance of them going to jail. So, and then a lot of times, it's, I've had criminal cases that took 2 years to develop. And those cases involved a large number of expert witnesses, toxicologists, pharmacologists, accident reconstruction experts, physicists, engineers, and these people are all over the country, and you have to take their depositions, and they're in other trials across the country, and you have to coordinate schedules with multiple lawyers and multiple experts, and many times that is a very time-consuming endeavor, and it's not necessarily a reflection that anybody's dragging their feet or failing to be diligent. And then when expert number one testifies that his opinion is whatever it is, then the other side has to have a reasonable opportunity, once they discover that information, to then go out and hire their own experts to come in and review what they did, review the raw data, and determine whether or not, in their expert opinion, they come to a different conclusion. And you can't just push a button and find a PhD who can do that on the spur of the moment. So there are plenty of reasons.
Yeah, I have to give them credit because it isn't a real detailed case. The party was like 0.09 or just barely over the limit. Mm-hmm. But for a public defender, I think that she has gone over and above to try to make a case that, of not guilty. They did a video of and reviewed the video, and it was a serious accident, not the person's fault. And they said, I don't think I should blow because I'm unsteady on my feet. But I give her credit,
Let me just say one quick thing because we're running out of time. I cannot say enough good things about the Public Defender's Office. They have the most dedicated, conscientious young men and women working there for not a lot of pay, a lot of stress, large numbers of cases, and it takes someone who has a special calling to do that. And the people that I know and have met and have seen in the courtroom all do an extraordinary job, especially with the resources they have to work with. And I simply cannot say enough nice things about the men and women who try cases in the Public Defender's Office here in this area.
I agree completely.
Thank you for calling.
You only have a moment.
Thank goodness we have public defenders. Some people would have no attorney at all, and I'm just amazed when somebody calls and you answer their question. The talent that you have, the skill that you bring to the courtroom and to this radio show is unparalleled. There's nobody who can do that.
You're very kind.
That I know. We are just about out of time. Do you want to give your phone number?
Yes,
our law firm is today.
Thanks to all our callers. Our law firm is Fuller & Fuller. We do personal injury and wrongful death cases or with serious accidents. We do major commercial litigation, complex family law matters, and Social Security disability cases. Our office number is 352-547-4292. Our toll-free number is 855-534-2565. If you or a member of your family or a friend has been injured in an accident or has a case that we handle, we'd be happy to talk with you.
Excellent. And call us if you need the phone number repeated, or just go online. Robin already puts the phone numbers on the guest list. You'll see John's name under the title Legally Yours at 10:35 on Wednesdays. Thank you, John.
Thank you, Larry.
What a great show. We'll take a little break. Be right back.
Broadcasting from the Paddock Mall Studios, this is WOCA, Ocala, Gainesville, The Villages, 1370 AM.